Now, civil society organizations have continued to express reservations about gifts given to judicial officers by the executives. This has been generating discussion as the judiciary makes deliberate effort to insulate itself from interference. Let's have this discussion with Victor Giwa, a legal practitioner. He joins us live in the studio now. Thank you so much, Victor, for joining us. I mean, Serap has been asking, has openly asked the president, to talk to the executive, members of the executive, not to interfere in the judicial matter, particularly as relates to gifts like cars, houses, and all of that. What risk does this practice pose to separation of powers? Could this give an impression, that the judiciary is beholden to the executive or maybe indebted to the executive?
Well, thank you very much. Yeah, I think the fear of civil society organizations and Nigeria in general is well-founded. But however, we need to put the record straight. Firstly, there's a difference between separation of power and separation of relationship. Now, there's judiciary is the third arm of government. There's the executive and the legislative arm. So, I mean, separation of power does not actually mean that there should not be relationship between the three arms of government. I mean, you need the relationship and the cooperation, collaboration with the three arms of government to ensure that democracy is protected, the rule of law is entrenched, and our democracy is, is enhanced. However, like Justice Kennedy said in 1989, that talking about judicial independence, he said that judicial independence is guaranteed when the court is insulated from pressure, ethnic, political, religious pressure from the executive, such that the court is not attached to the apron string of the executive, and that the court is well funded in such a way that the court will not become a beggarly institution to the executive. And I think that's what they're saying. Now, we need to state it here that those gifts coming from the executive is not a personal gift. It's not, for instance, you cannot say that it is not a personal gift from Wike to the courts. That is a gift coming from the executive arm of government. And like I said, there is always a need for collaborative effort between the various arms of government. But what is very important and fundamental is for the maintenance of the independence and the integrity of the judicial arm of government. That is what, to us, is very key, is to ensure that no matter that collaboration, that the judiciary is independent in their decision, in their work, in the dispensation of justice without fear and favor. To us, that is
so the question will now be, because quite a lot of people are asking that this gift, perhaps they are not captured in the budget. I mean, it's not in the budget provision. I mean, perhaps it's just something thought out. So how do we now prove that this is not, just a gift from the executive, that it's just something, that perhaps it's just about resources? That's one. Secondly, how do we balance the need for judges to have adequate resources while also ensuring that they remain free from political, influence? Because that is a concern here in the first place.
Good question. Section 84.7 and Section 1212 of the Constitution. Section 84.7 says that the recurrent expenditure of the judicial arm of government should be charged on the consolidated revenue fund of the Federation. So it therefore means that the fund for the judiciary should be based on the consolidated revenue fund, and it should go directly to the judiciary such that they can dispense. They have control of the funding. They have control of their salaries, control of everything attached to that institutions. However, we have not seen the capital expenditure. What we are seeing is the recurrent cars, buildings, accommodations. Ordinarily, what it should be is that everything about the judiciary, not just the recurrent expenditure, the total expenditure, both recurrent and capital, should be charged on the consolidated revenue fund of the Federation, and of course that of the state, such that when the budget is passed, the head of court, which is in this case the CJN, can administer. The court will talk about the salaries of the judicial officers, accommodation. So they don't need, like Justice Kayode said, the courts should not be a beggarly institution to the executive. So when the courts want to build, they should know the number of judges that they need to accommodate. They should have plans on how to build accommodations for their judicial officers. They should have plans on the issue of cars. But of course, the executive have always withheld fund for the judicial arm of government. And so that is why you always see some of these interventions coming from the executive. But if it should be avoided, they should avoid it. It is better that the judiciary administer itself. It buys its cars, it takes care of its capital expenditure, it does everything that pertains to it, such that you can't see the judicial arm of government giving anything to the executive or to the legislator. So it shouldn't be the executive too providing for the judiciary. It should be independent. They should be independent in terms of their funding, in terms of their administration, in terms of their expenditure, in terms of their revenue. So that is one of the best ways to ensure that the rule of law and democracy.
How do we make it open? Because you talked about the fact that these gifts perhaps are just from executive, because there's a provision in the budget, isn't it, for these judges, So if there are provisions already to take care of the welfare of the judges, the question will now be, why do we need to promote gift from the executive? That's one question. But again, Justice Kekere did mention that it will raise concern about how that some judges or members of the judiciary give bad names and ensure that they live a pure life or live up to the ethics of the profession. But then the question is, what might be some of the specific issues she's raising there, or could this be a direct response to some of the reactions that came up as a result of this gift from the executive?
No, first of all, ordinarily the gift from the executive supposedly is supposed to be given to the heads of court. For example, if the executive feels that they have certain things they want to provide for the judicial arm of government, the proper way to do that is to donate it to the head of the court, which in this case is the Chief Justice of the Federation. And the Chief Justice of the Federation herself does not necessarily be the person to go directly to have receipt of some of these items. Of course, there are various departments, the procurement department and all of that. That is okay. However, like what CJM, is not Honorable Justice Ekireku is saying is that, however, there are certain elements, very few, and she knows, as the CJN, that there are certain persons, certain judicial officers who have somehow, by their actions, been able to draw some bad image for the judiciary. And like you have said, there are very few of them. And I can tell you, the Nigerian judiciary has one of the best judges. They have judges who are very industrious, who are committed,
yes, of
who
course,
are living up the board.
Yes, she expressed that in the statement she put out earlier in the week. But again, there's a place for ethics, morality in judicial practice. Let's talk about that before I let you go, because the Chief Justice also highlighted this concern. Help us make sense of the current judicial system and the fact that, taking into perspective of the recent court ruling in Kano, there's a conflicting ruling about the local government election, of course, to this far south state of Rivers State. You still have another ruling there. So talk to us about these. In what way can the judiciary reinforce these values of trust to strengthen its role as a just institution?
Yes, I think the CJN, His Lordship Honorable Justice Kekere could have said, at emergence as the CJN of Chief Justice of the Federation, she has said that she's going to tackle such issues. And we have seen it in the past few weeks. A lot of judges have been asked to come and answer some questions. I know that the Chief Judge of the Federal High Court have been invited, and some other judges. I think that the NJC has the capacity to discipline itself, and that is what we have always been saying, that the CJN has come out to say that they are going to salvage the situation and discipline the erring judges who are doing that. But you can be rest assured that, like she has said and she's doing, that within the shortest time, the confidence of the judiciary will be recovered and rebuilt, and Nigerians can look at our judiciary and say of a truth that the confidence has been restored.
I like the fact that you say the confidence will be restored. So we hope that under Justice Kekere could, I mean, of course, that confidence and public trust will be restored in the judiciary. Thank you so much. Victor Giwa, National Coordinator Advocate for People's Rights and Justice. Thank you for coming on the news.
Thank you for having me.